business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Thank you all for being here today. We're so delighted to be at Lake Superior State. This is, of course, the first time that the Michigan Supreme Court has ever held an argument in the Upper Peninsula, and we're delighted to do that, and we're particularly delighted to be doing that on what we know is the 350th anniversary of the oldest city in Michigan, Sault Ste. Marie. So thank you all for your attendance here, and we hope you find this something of interest this morning. I do know something about Lake Superior State, and for that reason, I urge you to be kind to me and be kind to my colleagues if we inadvertently use one of the banished words that we're told by Lake Superior State we need to avoid. We'll do our best, but if we err in some respect, we hope you'll be understanding. Before I call today's case, I'd like to take just a few minutes to introduce my colleagues and thank our hosts from left to right. The members of the Supreme Court are Beth Clement, Richard Bernstein, Justice Bridget McCormick, Justice Brian Zara, Justice David Viviano, and Justice Kurt Wilder. We have an estimated 500 or 600 students today participating in this historic event. They are from the following schools, to the best of my understanding: Brimley, Cedarville, Detour, Ojibwe Charter, Pickford, Rudyard, Sault Ste. Marie, Whitefish, and there are also a number of homeschooled students here. We, of course, also have a number of Lake Superior University students, in particular from the criminal justice and the pre-law departments. Welcome to all of you, and thank you all for being here. We're also grateful to the Sault Ste. Marie Police Department, the Chippewa County Sheriff's Department, the Lake Superior State University safety staff, and the Michigan State Police for the security they've provided all of us. And we'd also like to welcome everyone watching today's events on our live stream. All of the oral arguments of this court are also available on live stream viewing. We also would like to thank all the persons here in Chippewa County, and in particular Sault Ste. Marie, who've been our local partners for this, our 22nd Community Connection Program. Each year, on one or two occasions, we go around the state of Michigan and we have a community connection event just like we're doing today. And this is the 22nd event that we've had, and those events are successful only to the extent that our local partners are enthusiastic and helpful in this process, and they've invariably been, and that is just as true of this event as it has been of our earlier events. Just a couple of very brief housekeeping items. First, with the exception of the media, please don't take photographs once oral arguments have begun. We hope you please won't do that. There will be opportunities for photographs during the reception that the justices will be joining you at after you're debriefed by the attorneys later on today. Secondly, if you've not already done so, please, please, please turn off your cell phones for the remainder of these proceedings. Both the cameras and the cell phones can sometimes be distracting to the court and to the attorneys during these proceedings. Very briefly, the Michigan Supreme Court is the highest court in the state of Michigan. There's basically three tiers of our judicial system. Of course, we have the trial courts of our state, probate courts, circuit courts, district courts, in which there is a single trial judge. There's often a jury. There are typically witnesses, and we have cases introduced into our legal system at that point. One of the truths about trials in our state, as in most other states, is that there's a winning party and a losing party. The losing party in those trials generally has a right to seek an appeal to the second tier of the system, which is our Court of Appeals. Our Court of Appeals has 3 judges sitting, and they don't take testimony in the same way that the trial courts do. They look at the testimony by reviewing the transcripts of the proceedings that have taken place in the trial court, and their job is principally to determine whether there have been errors at trial that warrant a reversal of the results that have been reached at trial. When the 3 judges on the Court of Appeals have completed their deliberation, of course, there continues to be a winner and a loser, and the losing party has one last opportunity generally to seek the assistance of this court in reversing the proceedings below. And that's essentially what's happening today. We are hearing an appeal, one of the roughly 200 appeals that we get per month. We are hearing oral arguments, and we've chosen this as a case in which to hear oral arguments because we think that we can benefit further from hearing from the lawyers, asking them questions about perhaps difficult or confusing legal aspects of this case. And that's why we think this is a case in which all of us can benefit from hearing the parties share their thoughts with us. After we hear the arguments today, and each side will have roughly 15 minutes, we will retire into our conference room and we will begin very briefly our discussions and our back and forth analysis of the legal aspects of this case. We'll continue that when we return to Lansing, and possibly several days, several weeks, several months from now, we will issue an order or an opinion in which we attempt to resolve this case. And our understanding is that many of you will be discussing those opinions or those orders and assessing whether or not, in your judgment, we've done the right thing or the wrong thing in those cases. Let me just emphasize one final thing before we proceed, and that is, as I think all of you know, we in Michigan, under our Constitution, just as under our federal Constitution, have a system of separated powers. And there's nothing more important to understand about what we're doing this morning than that we have a system of separated powers. We have the 3 branches, the legislative, the executive, and the judicial branch. The legislative branch enacts the public policies of the state. The legislative branch, whether it's our legislature in Lansing, our Congress in Washington, our county commissions, our city councils, they enact the policies of our state. Those are enforced by our executive branch, and it's our principal duty and responsibility and power on this court to review those laws and policies and to try to understand what they mean, and in the course of doing so, resolving the controversies and the disputes that are coming before this court, including in the case that we have today. And we hope that if you understand nothing more substantially than this separation of power system and watch at least one piece of it in action today, you'll be able to go into the world as better citizens, because our system of government depends upon the citizenry being aware and knowledgeable of how its processes work, and we hope this will contribute, at least in some small way, to all of you understanding how the judicial part of our process works, including the relatively obscure part of the judicial process that you'll be seeing today, the appellate judicial process. Also, speaking of history, I'd like to briefly call the attention of the history buffs among you, teachers and students alike, that our court has been blessed over its 180 years by 8 justices from the Upper Peninsula of Michigan, including 2 justices from Sault Ste. Marie. From 1911 to 1927, Justice Joseph Steer served on this court. According to his official biography, Justice Steer, a Quaker, left this community on his passing in 1927 an enormously important historical library of this region of the Upper Peninsula, and he was a painstaking scholar of the natural history of the Upper Peninsula, its birds, its flowers, and its wildlife. Prior to his service on this court, Justice Steer served as your prosecutor in Chippewa County for 4 years and as a circuit court and trial court judge for nearly 30 years. More recently, Paul Adams, a graduate of Sault Ste. Marie High School, a Blue Devil I think it is, served as justice from 1962 to 1973 after having served as mayor of this city and as Attorney General of the state of Michigan. And if among you today there is possibly someone from the Sault Ste. Marie, the Chippewa County area, who will someday become a third or fourth justice of this court from this part of our state, we encourage you in that endeavor, for you, as we have, will find it an extraordinary opportunity to contribute to the development of the rule of law within your state, one of the great achievements, one of the great accomplishments of our civilization. It has been a remarkable opportunity for each of us on this bench, I know, and if one of you has that opportunity someday to represent this part of the state on the highest court of Michigan, we know that you will find it a similarly satisfying opportunity. Finally, my colleagues and I do want to take credit for bringing at least a small bit of spring to the Upper Peninsula. It was beautiful yesterday, a little bit less beautiful this morning, but very beautiful yesterday. We will take at least a small amount of credit for that if there's no objection. We'd like to call the case that we have this morning. It is called Bertin versus Mann. Each of the parties will have 15 minutes for argument. The appellant, that is the party that's seeking to reverse what's happened in the Court of Appeals, will begin the arguments. The counsel for the appellant will be able to reserve some time if counsel would like to do that. Otherwise, there will be 15 minutes for each side. And understand that the questions that we possibly will have for the parties are not designed to intrude upon the process or interfere with their thinking, but to call to their attention the concerns of the court in its effort to try to understand this case as well as possible. So let's begin first, if we can, with the appellant, and the appellant will introduce herself.
Good morning. May it please the court. Sydney Klingler, appearing on behalf of the defendant appellant, Douglas Mann. This case involves Michigan's recreational activities doctrine, which adopted reckless misconduct as the minimum standard of care for co-participants in recreational activities. The parties have been asked whether the reckless misconduct standard of care or the ordinary negligence standard of care applies to an injury resulting from the operation of a golf cart while playing golf recreationally. Now, of course, we look to the case of Richie Gamester versus City of Berkeley. In that case, this court explained that when people engage in a recreational activity, they voluntarily subject themselves to certain risks inherent in that activity. When one of those risks results in injury, the participant has no grounds for complaint. But the Court of Appeals in this case focused in very narrowly on one word in the Richie Gamester opinion, and that is inherent. The court essentially concluded that because golf can be played without a golf cart, then the risk of injury from a golf cart is not a risk inherent to the game of golf. But an examination of the Richie Gamester opinion shows us that the court never intended to adopt such a narrow definition of inherent risks. Instead, a party's knowledge of the risk, its known or apparent nature, are key to the doctrine, to the recreational activities doctrine. For example, the court in Richie Gamester talked about foreseeable, built-in risks of harm. The court in Richie Gamester said an occasional injury is a foreseeable and natural part of being involved in recreational activities. The court even looked to participant expectations as a benchmark for the doctrine, reasoning that our standard more nearly comports with the common sense understanding that participants in these activities bring to them. So clearly, foreseeability is an underpinning of the recreational activities doctrine, which is based on concepts like consent, notice, assumption of the risk. And those doctrines were also apparent in the cases from other states that this court relied on in adopting the recreational activities doctrine. For example, Turcotte versus Fell, a New York case involving a jockey who was injured during a horse race and sued a fellow jockey. The court emphasized knowledge of the risk.
Counsel, I understand how in a contact sport context, basketball or football, injuries are going to occur despite the best and most careful efforts of the contestants. But why should we expect any less care in the sport of golf when the issue is the driving of a motor vehicle? Why should we expect any less care than when you're driving a motor vehicle in a non-sporting context on the street or otherwise? There's nobody who's not cognizant of the serious harm that even a motorized golfing vehicle can do to somebody if it's not managed carefully. Why should there be a difference in this context as opposed to a more traditional kind of sporting context?
Your Honor, the reason for that, stated very broadly, is because this activity is part of the game of golf occurring on a golf course. And and maybe you're asking why the golf cart isn't regulated by the Motor Vehicle Code. The golf cart is not regulated by the Motor Vehicle Code because no statute prescribes the manner in which a golf cart should be operated on a golf course. In fact, only one statute applies to the operation of golf carts, and that's under limited circumstances enacted after the events of this case on city streets and on city streets.
Counsel, good morning and welcome.
Thank you.
Help me to understand then, what exactly is a golf cart?
A golf cart, well, a golf cart is a vehicle used for the game of golf to transport the golfers.
But I can play golf without a golf cart, can I not?
That's true, and I think that was the error of the Court of Appeals in very narrowly defining the word inherent. Golf carts...
But let me ask you a question. Couldn't one put forth the argument that in many situations a golf cart is more of an accommodation to the playing of the sport? You know, for a person that has a disability, if you look at the Casey Anthony case, if you look at that kind of an issue, could it not be argued that the golf cart is more an entity that creates an accessibility rather than an essential component of the sport or of the game itself?
That's what the Court of Appeals reasoned. The game can be played without a cart. But carts are ubiquitous today to the game of golf. The United States Supreme Court in PGA Tour versus Martin acknowledged that, said they're everywhere. They are encouraged. They speed play, and they're great revenue producers. The Indiana court in the Wooten case added they are part and parcel of the modern game.
Counselor, what about courses that prohibit golf carts completely? The game's required to be played on foot.
Well, in that case, of course, this kind of injury could not occur. But I think that what we have to do is look to the particular circumstances, and that's because the court in Ritchie Gamester talked about consent, talked about knowledge, talked about assumption of the risk. Those doctrines look at the knowledge of the plaintiff or the apparent nature of the risk. So we have to look at the particular circumstances, and in this case we had a course, of course, that did allow golf carts. Not only that, the plaintiff knowingly and voluntarily accepted any risk associated with the use of a golf cart when he began a game of golf with the aid of a cart. In fact, our specific evidence in this case shows that the defendant, who was 88 years old at the time of these events, never played golf without a cart. So it would be impossible for the plaintiff to have engaged in this game without a cart.
But that proves too much. I mean, it's one thing to say that the plaintiff assumes a certain amount of risk associated with a golf cart when he plays golf with a golf cart, right? That's like any other sport. You know, we don't want every football player suing for every tackle. But the recklessness negligence line is a little bit sloppy, right? Because in fact, it's even true that some intentional acts we don't allow recovery for when people are co-participants in sports. But having said that, it can't be your view that the plaintiff has consented to or assumed the risk of any kind of injury from a golf cart, right? If, for
No,
example,
I don't believe
if
he would have accepted the risk of an intentional injury, for example.
Well, or a reckless one from your perspective. You think?
Well, I think he did, because golf carts carry with them a risk of injury. Once a golf cart is involved in the game, they carry with them a risk of injury. And if we look at that Wooten case from Indiana, the court said golf cart collisions, in that case, a person was injured in a golf cart, a collision between two golf carts.
But wait, your argument is not that the plaintiff assumes the risk of reckless conduct with a golf
No,
cart.
absolutely
Okay,
not.
so
In that case, Mr. Mann would be liable. The jury found that he was not reckless.
But I know this is a long wind-up, and I apologize. Let me get to what I think I'm asking. I'm worried that negligence, recklessness is just a sloppy line. And what we really mean by those categories is you assume certain risks when you play a sport or you engage in some other recreational activity. By the way, sports are not special. This is just one application of negligence law. If you're a veterinarian, you assume the risk of being bitten by a dog. So sports are really not special. Having said that, it's shorthand. Like you assume some risks, and which of those are ones that we will say are that the plaintiff can never recover from. Some of those are fit in that category, and some don't. So if the co-participant in the golf game decided to do a bunch of wheelies with the golf cart and pull it up on two wheels, and the plaintiff was injured as a result of that, you would say the plaintiff could recover, correct?
I would say that was reckless misconduct, yes.
Maybe, maybe not. My question is, isn't it going to be the case that some activities associated with golf carts will be risks that you can say a plaintiff assumes and some not? Isn't there just going to be a spectrum?
I think the court in Ritchie Gamester drew that line, and they did say this has to be a case-by-case determination, but they drew that line between negligent conduct and intentional, or
But that's
reckless
the line that's hard to draw.
misconduct.
What would be wrong with saying to the jury, hey, jury, here's the rule. If you find that what happened here is the kind of thing that when you play golf, you assume the risk that this could happen to you, then it's a complete defense. The defendant is not liable. But if you find this is not the kind of thing that you could expect to happen in the game of golf, then we have an ordinary negligence standard. What would be wrong with approaching it that way?
Then I'm sorry, I'm not sure I understood the last part of the question, Your Honor.
What I'm trying to say is, I don't believe there are going to be some injuries where it's going to be really easy for a court to decide. Probably Mr. Bindor wouldn't bring the case. If an errant golf ball hits a co-participant, I promise you Mr. Bindor would not bring that case. Mm-hmm. Right? Right. But with a golf cart, it seems like a murkier area, right? You could imagine some golf cart accidents being the kind of things that you would expect and others not. So what would be wrong with saying to the jury, here's the rule. When you play golf, you assume certain risks. You, jury, decide if this is the kind of risk you should have assumed. If so, no luck, plaintiff, you're out. If you don't think it's the kind of risk you would have assumed, if it's wheelies and, can you do that with a golf cart? I don't know.
I don't know. I think that the answer is that you're essentially asking the jury to define an inherent or foreseeable risk.
Juries do that all the time. We trust juries to do that all the time.
I think that the court in Ritchie Gamester undertook to make that determination. I think that it's a rule of the common law at this point, that reckless misconduct is the line where we impose liability on it, in a recreational activity.
So the court has to decide ahead of time whether it was reckless or just negligent. And if it's just negligent, why are we saying it to the jury at all?
No, the court doesn't decide whether it's reckless or negligent. That's for the jury.
Okay.
Do you agree that Richie Gamester is a pure assumption of the risk case?
Well, assumption of the risk has questionable status in Michigan. I think assumption of the risk was incorporated into the Richie Gamester case, where the court said you can call it assumption of the risk, you can call it notice, you can call it, I think they even said implied contract, but the bottom line is this: when a person engages in a sport, they consent to certain risks that are inherent in that sport. And then, of course, the court did talk about foreseeability in various places in its opinion.
Are you asking us to adopt a foreseeability standard?
I think that no, not strict foreseeability, but I think foreseeability and the obvious or apparent nature of the risk is a critical part of defining an inherent risk.
So you want to keep us under the umbrella of the inherent nature of golf?
That's right. I think that as the court used the word inherent risk in Richie Gamester, they meant risks that are apparent or obvious.
Are you troubled at all by what Justice Scalia called in his dissent in the PGA Tour case versus Martin, the ADA case, the Alice in Wonderland determination that there are such things as judicially determinable essential and non-essential rules of a made-up game like golf? Does that trouble you at all, or do you think he was onto something there, or do you think
essential or non-essential rules?
How we determine what's inherent to golf or the game of golf or any recreational activity?
We look generally at the game.
Well, hang on, I'm not asking you how to do it. I'm asking you the first order question of whether it's a fool's errand to try to do it at all, which is the point that Justice Scalia made, I think, so eloquently in his dissent. Do you agree with that, or do you disagree, or no position?
No, I don't think it's a fool's errand. I think the court can determine that this risk was inherent in the game of golf because carts are ubiquitous, they're everywhere on a golf course, and because when we look at our particular circumstances, and I'm going to need to finish up here because I'm saving 2 minutes for rebuttal, because when we look at our particular circumstances, our plaintiff undertook a game of golf, and he thereby undertook that risk. And I see that my time is now up.
Actually, counsel, I promise you, I'll ask you a question to let you come back. So, but my question is, and it's so funny because I have to do this all from memory, so I have to internalize all this. So I said Anthony, but I meant Martin when I was talking about the PGA case.
Yes.
So, but like I say, if you got to memorize all these cases, sometimes names get mixed up. But going back to Martin and the issue as it pertains to Martin, is the issue that you have with the cart itself? That's what I'm trying to understand. Is it the fact that, is your entire focus that we're talking about the cart in of itself is what the danger is?
I think we're saying, if I understand you correctly.
Yeah, because you were talking about the motor vehicle code. So my question is that, is your focus on the fact that it's the inherent danger of this, that the cart itself is inherent to the game? Like, what if you had a greenskeeper that was on the course that was using, a motorized vehicle on the course? Would that change the dynamic here?
I think it would, because that person is not a co-participant, so then they fall outside the doctrine of Richie Gamester.
So what if I wasn't using a golf cart, but I was using some other mechanized vehicle? Would that alter your decision or determination in this?
What type of
He rides a
mechanized?
moped on the golf course.
Right.
I'm sorry.
Moped, he rides a moped on the golf course.
I'm just that kind of guy, I like to spice it up a little.
What type of mechanized vehicle?
I'm sorry?
You said if you had
My
some.
question is your focus exclusively around the fact that it's a golf cart Or could it be, or if they were using some other mechanized vehicle, would that make a difference in your determination here?
If the golfers were using some other mechanized
Yes, just
vehicle?
any other type of mechanized vehicle that they were using.
Well, it's hard for me to picture that
Well, like a- well, let's
scenario.
They said a four-wheeler, they wanted to take, they had a cool four-wheeler, they liked it, they wanted to take it on the golf course that day.
Well, four-wheelers bring up a whole other issue, because those were discussed in the case of Van Gilder versus Collier, and those are regulated by the Motor Vehicle Code, contrasted with golf carts. They are heavily regulated by the Motor Vehicle Code. So yes, that would be different.
So is the whole essence here, I mean, would you be basically, I guess the question I have here, is the entire essence here, the motor vehicle code, is that kind of the essence here, that if it's not regulated by the motor vehicle code, then that would be an inherent part of the game?
No, I don't think that those are necessarily tied together. I do think that the golf cart when on a golf course is not regulated by the Motor Vehicle
Right, no, I
Code.
understand. And is that the whole reason that you're saying that there's a distinguishing component to it?
No, I think it's also inherent in the game, just when we look at it factually.
So let me ask you a question then. Going in this concept, I'm going to give you a hypothetical. So my passion, I love to run, and I like to run marathons. Now, the essence of running a marathon is that you run through cities. That's the whole beauty of running a marathon, is that you run through city streets. And I'm going to ask you two questions, and then we'll kind of go from there. So you're running a marathon, and you're running through the streets of the city, and this happens often sometimes in marathons. And as you're running a marathon, a vehicle comes onto the course and strikes you. Now, would it be your argument that running a marathon within a city and getting struck by a vehicle as you're running within the confines of the marathon, would that then is that an inherent part of the sport? Because marathon running can only happen in those types of environments. So if you get hit by a vehicle, would that basically be an inherent risk to running a marathon?
Well, I think that it's a very different hypothetical from what we have in our case.
Not really.
But
You're running a race, you're in a city. The whole essence of a marathon is that you run through cities. It's part of the sport, that people like to do it. And you're running, and there's traffic, and a car comes on the course. They can't block every intersection. Sometimes they miss some, and it happens sometimes. Or you're running a race, and a vehicle comes onto the course. You're running on a city street, you get hit by a vehicle.
I don't see it as an inherent part of a race to be hit by a vehicle.
You don't see it. So all right, so let me take you one step further then. So your perspective on that is that you would not then see that as that would not be an inherent risk running a marathon. If you were to get struck by a vehicle while you're running, you would not see that as an inherent risk to the actual running of a marathon, correct? What you just said. I just want to make sure I got it correct.
I don't think so.
Okay, let me take the hypothetical one step further. Often in marathons, what happens is that people have to get from place to place. They have to, staff and different people have to get from place to place. Other runners sometimes have to get from place to place. And if you're blind, often it's the case that guides have to sometimes get from place to place. So it isn't always uncommon for them to use golf carts in that kind of a situation. So let me ask you this question. You're running a marathon, and, one of the people, let's say it's another runner, or it's a person who is going to a different section of the marathon to run, let's say, a relay. And in certain situations, they use golf carts to get them from point A to point B to line them up for that location. You're running the marathon, you're in the race, a golf cart strikes you while you're running. Would that be inherent? Now I've given you a hypothetical where you have a golf cart that's actually being used in a situation by, in many situations, other runners who are going from place to place. Would that then become an inherent part? Would you argue that that would be inherent?
Well, maybe I'll change my previous answer.
Okay.
Because I think that a golf cart, once you take it onto a city street, is, again, as we talked about the Motor Vehicle Code, it's governed by different rules. We're talking about a golf cart on a golf course. It is not governed by any statute.
Well, but wait, is the issue that's what I'm trying to understand with your argument. Is the issue the fact that it's a golf cart, or is it the issue as to where it's being used? So if it's being used in a different, I mean, is your issue, if you're using a golf cart outside the confines of golf, is that the issue? And people use golf carts all the time, and these are other athletic competitions in which golf carts are actually being used. I've given you the example of a runner getting from one section of a race to another to be a part of a relay. So
Yes, I believe where it's
being
being used is critical. It does
Okay.
matter.
Counsel, I have one question I'd like to ask you.
Yes.
And I've read the briefs, but I'd really like the most clear, direct, concise answer that you can give. This is a common law case. Because of that, there's an element of public policy that which obligation is imposed upon this court to make some judgments concerning whether things should be this way or that way. I understand perfectly the idea that when you're talking about body checks in hockey or tackles in football or hit by pitches in baseball or rebounds in basketball, why there ought to be some higher standard and some protections so we don't open up the spigots to more and more and more litigation stemming out of sporting activities. But why, when somebody takes the wheel of a motorized vehicle, which we all know can cause serious injury if not handled properly, why we ought to make a distinction, why this court ought to make a distinction in the law of Michigan between a driver who's sitting in an automobile, a motorcycle, a bus, or a truck, and a driver who is sitting instead in a golf cart, a bullpen car, or a Zamboni machine, simply because they're incident in some way to a sporting activity. Why should there be a difference? Please summarize your response to me as concisely as you can.
The reason that the court in Ritchie Gamester explained for its doctrine is that one
I'm asking you. I understand what Ritchie Gamester said. What is your response?
That one undertakes a risk. One has knowledge. One consents to a risk when one engages in a sport.
So the standard for somebody who takes the wheel in this one class of motorized vehicle is going to be completely distinct from the standard applicable to those who take the motor vehicle in a sporting context.
To say that, I'm sorry, can you say it again?
Why should somebody who has placed himself before the wheel of a vehicle in a incidentally sporting context, why should he have a more relaxed standard than somebody who places himself before a wheel in a non-sporting context?
Yes. Because the reason is because the co-participant has consented to the risks that are inherent in that activity. He knows. It's an apparent risk.
Okay, you've said that. Okay, I appreciate it. Any further questions? Okay, thank you, Counsel.
Thank you.
Good morning. May it please the court, Mark Bendura on behalf of plaintiff appellee Ken Bertin.
Speak up, sir.
And if I may, I'd like to thank everybody for the opportunity to participate in this historic event and to enjoy the hospitality of those who have hosted us. What the defense asks the court to do is to expand the judge-made Ritchie Gamester decision so that the loss and economic burden of being run over by a golf cart is imposed upon the blameless person who gets run over rather than the negligent driver who caused the injury. And when you put it in those terms, I think you understand a major policy behind the law of negligence in general. Plaintiff's position is really twofold. First of all, this is a case which involves a motor vehicle. I think it's subject to the Motor Vehicle Code itself. It is certainly a motor vehicle within the definition of MCL 257.33, which defines a motor vehicle as every vehicle that is self-propelled. In addition, we have the owner's liability statute, which adopts a negligence standard of liability. We have a full body of law that says when you negligently drive a motor vehicle, you're liable. Our position is that the Ritchie Gamester doctrine ought not be applied to injuries arising from the use of a motor vehicle. And frankly, if we are correct that it is covered by the Motor Vehicle Code, then we get into the separation of powers doctrine that Chief Justice Markman so adroitly mentioned. If the legislature is not creating an immunity of this nature, despite extensive legislation regarding the operation of motor vehicles, we suggest the court not ought to go further to create a judge-made doctrine which at least clashes in principle with the liability that's allowed under the Motor Vehicle Code. And note,
would the Motor Vehicle Code apply to demolition derby or to stock car racing?
theoretically it might.
No, that's not, we can't let every race car driver can't sue when they crash, right?
No, that's true.
Because they've assumed that risk.
Because
they've assumed the risk. I'm gonna go be a race car driver, I assume the risk of crashing, don't
Sure.
I? So that can't be right. You have to,
Well, but the
you need to
Van
give us a little closer.
But the Van Gilder case, the Court of Appeals said it applied to off-road vehicles in an off-road injury because it was covered by the Motor Vehicle Code. But putting that aside, I think that is at least a reason to show caution before creating judge-made immunities. But and let me point out, and I think it was adverted to, I think of the Toronto tragedy, where there were pedestrians in an area that had a lot more motor vehicles than the golf course. And can it be said that by walking in an area where there are motor vehicles that is consent? It can't be.
I mean, I think we're pretty clearly here talking about co-participants in a recreational activity. So someone who's driving a vehicle who's not part of the activity, that doesn't really help us at all to answer the question here, does it?
Well, it does in the sense that I don't see any rational reason for the distinction, particularly when you're talking about golf carts, which are not an inherent part of the game. If we're talking about something that is...
Well, that sort of begs the question in a way, if the question is properly put, what is inherent to the game? Let me ask you this question.
Sure.
Instead of, as I suggested to opposing counsel, instead of us trying to figure out what's essential or inherent to some grand notion of the game of golf,
Okay.
which I play golf, and I'm sure I have a different conception of golf than a lot of other people who play golf, right? Certainly a different skill level. But my mind being less, by the way, not more. But what's wrong with a standard of foreseeability, asking whether the risk was foreseeable to this particular plaintiff on this particular day? So, for example, instead of looking at whether there's some, as Justice Clement noted, there's some courses that don't allow golf carts. Well, it wouldn't be foreseeable, really, to be injured by a golf cart at a golf course that doesn't allow participants to use them, but maybe it would be foreseeable to be injured by the ordinary negligence of someone driving a golf cart on a course that routinely allows and permits their use. What's wrong with framing the inquiry in that fashion?
Because if you're talking about people consenting to anything that's foreseeable, you're talking about virtually the entire range of human activity. And why should you...
Well, you're going a little bit broad. I'm talking about co-participants in a recreational sport, consenting, I guess to use your word, to the risks that are foreseeable.
Because that is contrary to the Ritchie Gamester case, which took considerable pains to use the term inherent. I looked at...
It's sort of a grab bag of terms. Didn't Ritchie Gamester sort of used a bunch of different terms? I can find foreseeability in that case. You can find inherent. There's a couple other things we could find there. That's sort of why we're here today, right? To figure out what the standard is.
Even the most
And as you know, we like to ask what the standard should be. As
Certainly.
Justice Markman, our Chief Justice, said, we're talking about the common law, and it's our duty to understand not only what that case said, but whether what that case said has established a clear standard for people so that the public knows and understands their obligations when they go golfing or engage in other sports or other recreational activities.
But I think inherent is a critical distinction, because you're saying that the whole idea of assuming a risk is based upon the fact that you are participating in this sport. And that's what you are to have consented to, the risks inherent to that sport. Not just once I step on a golf course or a soccer field, I'm fair game for any injury that might result.
But you're defining it pretty narrowly. It doesn't say inherent in the sport, inherent in the game, inherent in golf. Doesn't it generally say inherent in the activity? I mean, activity kind of connotates a broader understanding of what it is you do. When you go to the golf course and you rent a golf cart and you're going on, the course for 18 holes and you're going back and forth in your cart, all that time you're engaging in the activity, if not necessarily the narrower conception of the game itself. If you're sitting in a dugout and you get hit by a baseball, you may not be participating in baseball at that moment, but you can fairly be said to be participating in the activity of baseball.
But it's the risk inherent that's important. You are at risk while sitting in a dugout of being hit by a baseball, because a baseball is a necessary implement of the game. You may not be consenting to being hit by a football or a golf ball, but if the risk that you are assuming is inherent in that game, which is baseballs and bats. And interestingly, Richie Gamester itself, in the Texas case it cited, spoke of errant shots. And that really is that's exactly why the rule exists. Because every single person and every single shot on every single golf course, by the very nature of the game, hits a ball with a club that is possibly errant. And that's why that is inherent.
What if somebody throws their club? Is that inherent in the game?
No.
Why not?
Because it's not accepted as part of the game that you throw your clubs.
Is it only things that are in accordance with the rules of the game that are inherent, or are there, so if you're playing hockey and you cross-check somebody, is that not an inherent risk of the game because that's in violation of the rules of hockey?
No, that is actionable, and that's why it's explained in Richard Gamester, that it's the physical contact that is part of the game. Now, if you're talking about the difference between
but it's in violation of the rules.
It is.
Just like throwing your golf club, I assume.
So is roughing the punter, and so is a foul on the soccer courts. And as you go to the policy reasons that are listed in Richie Gamester, one is that it would deter the fervor of the game, or that it would create such a deterrence that nobody would want to participate in the game. And so that's why...
Aren't we at risk of doing that? When I go to play golf and drive the golf cart, and something I think about the facts of this case, if I'm not mistaken, the other golfer was driving most of the time, and then there was an occasion for the defendant to jump in the seat, or maybe he was asked to do that. Now, if I'm on the golf course, and I'm not really one who likes to drive, and frankly I don't, and someone asks me to drive, if I know that if I make a mistake and somebody gets hurt that I can be sued, wouldn't you be more reticent and say, hey, hold on a second, or here, pull out a waiver, sign this waiver, I'm not going to drive you because if I make a wrong turn and you fall out of the golf cart, then I'm going to be sued. So doesn't it have exactly that impact that you're trying to avoid?
I've played a fair amount of golf, and I can't recall ever before the round saying, boy, I know I'm at risk of somebody running over my ankle and breaking it, but I'm going to weigh that risk and make a conscious decision to assume that risk.
Why does the golf course give me a waiver form and make me sign it and put my driver's license number on it? And
now
why do they want a waiver every time they let me use their golf cart? They know there's a risk there.
And now you've got a knowing assumption of that risk, which is quite different than having some sort of imputed assumption or consent to some risk
But that's the whole point of Richie Gamester. We're not going to require you to sign a waiver. When you participate in the sport, you are assuming the risks. And if you participate in the sport of golf and choose to take a cart, why aren't you assuming the risks that normally may come from the operation of the cart?
Well, first of all, my client didn't even choose to play with this person. He was paired with them.
But he chose to play in a cart, in an electric golf cart.
Actually, he was walking when he got run over. But I understand that a cart is part of the game. It's part of the game. But that, in my mind, doesn't comport with the policy behind assuming risks inherent in the game. Much like Richie Gamester, I think it's pages 86 and 87, the terms inherent risk and inherent are used 4 or 5 times.
What game was being played in Richie Gamester? It's an activity, it's not the game.
It was a recreational
game in Richie Gamester. What are the rules of open skate ice skating?
There are none that I'm aware of.
Exactly, it's the activity, it's not the game.
But there is in golf an elaborate set of rules that was established before the United States even existed, which identifies the inherent components of golf: a ball, a club, striking from a tee ground to a hole. And that's why Richie Gamester
You
and the case...
suggested you wouldn't have a cause of action by being hit with a ball.
Pardon me?
You suggested when
That's correct.
that you wouldn't bring a cause of action from being hit by a ball.
That's an inherent risk
What
of
if
the
the
game.
person hit the ball right down the middle of the fairway, saw the participants in the fairway, and didn't yell for?
Still no
Still
injury.
an assumption of the risk.
That's
What
correct.
about the rule, the unwritten rule of golf that you yell for?
Well, that's an unwritten rule, and I'm not sure that's quite the same as the formal rules when you're talking about what you're consenting to.
So
But-
even though there is no set of rules in Richie Gamester, we should make decisions on sporting activities based upon the rules.
They talk about the inherent risks, and I think the inherent risks are generally defined by the rules.
And so it doesn't extend to the inherent risks of operating a golf cart when you take a golf cart, when you put your clubs on the cart.
I don't think so. Let me take it a step further. Many times I and a lot of other golfers have walked the course or carried a pull cart. What if it's somebody from the next hole who's driving over and runs me over? Does it make any real policy difference to say that because we happen to coincidentally be on the course at the same time, I have consented to being run over?
But if it's not someone in your foursome that hits the errant shot and hits you, does that mean you
Co-participant.
have a cause of action against the person you aren't playing with?
I'm sorry, what's that?
If you get hit by a ball from someone who's not in your foursome,
Yeah.
now do you have a cause of action because they're not a co-participant to your?
They are a co-participant, which is exactly why there's no liability or why there's no negligence liability.
Well, if someone who's not in your foursome is a co-participant, why wouldn't then someone who's driving a golf cart outside of your foursome also be a co-participant?
They are a co-participant. And that's the rule why if someone on hole number 4 hits an errant drive that nails someone on hole number 7, the golfer on hole number 7 has no cause of action, even though he has no idea that the other golfer even exists, much less consenting to being hit by him.
Mr. Bindor, can I try a little bit? Because I think you've said a couple different things. I thought you were saying that the question is what risk is inherent to the activity, not whether golf carts are inherent to golf. That's sort of a silly question, and a silly question for courts to have to sort out, right? The question is, and it's because sports aren't special. This is just, tort law, right? I mean, we could talk about veterinarians getting bitten by dogs. There are risks certain people assume. Sports and recreational activities are one big category, right? Where we say that when people decide to play football, they assume the risk that they are going to be tackled, and we're not going to permit people to sue people for being tackled. That's actually an intentional act, so the recklessness, negligence line is a little sloppy, right?
Well, there's actually the intentional roughing into the kicker and the unintentional, but either way.
What I mean, right? I mean, some intentional activity, we say there's no liability for in sport, and the reason is that the normal and expected risks of the activity are ones that we say you can't recover for, right? Those are so the question is the risk of something happening with a golf cart something that is kind of normal and expected when you play golf? And why isn't it possible that the answer is sometimes yes, sometimes no?
I think if you're talking about the background of all of this, one of the reasons, or at least a major reason, for this exemption is that because some of these sports necessarily subject you to risks that you wouldn't in other contexts.
Well, you assume, it's not they'll subject, you assume them. You want to play football. You are willing to go be tackled, right? So we want to have, you know, the law has this shorthand, sort of hands-off approach to people who participate in activities like that, right? We can't let every football player sue every other football player.
That's true, but I still think the inherent risk doctrine is critical, not only from the precedential aspect, but because it's not that stepping onto a football field or a baseball diamond or a hockey rink or anything else subjects you to risks that are comparable to would exist elsewhere, such as being struck by a motor vehicle. What they do constitute consent to is those risks that are inherent in the sport.
Absolutely. If you and I play football together and you tackle me, I'm not going to sue you. Right. If you tackle me on my way off the stage today, I might.
Yes,
right?
Exactly.
Okay.
Or if I get hit by a baseball while I'm batting,
right.
I don't have a cause of action.
Right.
But if I'm playing tennis and someone nails me with a baseball, I do.
But so why isn't it, when I play golf, isn't it fair to think that there are some risks with a golf cart? You might say, not the one of getting run over by one, but falling off the golf court, you know, stepping down from it and not noticing that it's a little further down than I thought, losing my balance when I'm trying to get I've never played golf, so I'm making all this up.
Tight turns. Tight turns.
You know, some of those things are just, you know,
A lot of
risks that you have to assume are inherent to the activity, and others might not be, right?
A lot of your examples, though, are things where it's injury to yourself rather than through the negligence of another person. That, I think, is a critical distinction, where you not only have the venue of a sporting or other type event, but you have a risk that you have subjected yourself to that you would not be at risk elsewhere. And that's where I think the motor vehicle aspect of the case becomes significant, because I don't think, other than the fact that the location is on a golf course, that risk is not different in kind than the risk you assume walking on a public street or in any other circumstance where your body is close to that of a motor vehicle.
Any further questions? Your time is up, Mr.
Okay,
Bertin.
thank you very much, Your Honor.
Counsel, I promise that, or the second counsel, the plaintiff, the defendant. I promised I would give you a.
Counsel, please come up here again.
I promised I would ask you a question because I took away your time. So I just think, in the essence of good sportsmanship, I thought it would be fair to bring you back up because you had asked, you were very conscious of your time and I took up your time. So I'm going to ask you a question and it's going to give you an opportunity to answer. The question I'm going to ask you is, just looking at this from a pragmatic sense, you have a person on a golf course that gets struck by a golf cart. Under your argument, what should the plaintiff, what should the injured party have done differently in this case?
I'm not saying that the plaintiff should or could have done anything differently. I'm saying that there is a risk that that was part of the use of a golf cart that he undertook when he used a golf cart.
So in this situation, basically, the simple essence of the fact that they went to play golf and a cart was used, you're saying this person, based on your entire argument, just in a pragmatic sense, so anyone who goes on a golf cart and plays golf and wants to participate, wants to do this, it's your argument that if someone takes out a golf cart, goes and plays golf, that they've assumed the risk, and if they get struck and if they get injured horribly, that's it. They have no way of recovery.
Well, it's not that they have no way of recovering. They could recover if the injury were due to reckless misconduct with the cart.
Right, but that's a very high standard. So, I mean, the question here is, from a pragmatic sense, I'm just trying to lay it out kind of in a very practical sense in terms of what this actually means to real people who are playing golf. And under your perspective, if someone goes to play golf and a golf cart is used and they get struck in this situation, you want to impose a very, very high standard in which to make it difficult for them to be able to seek any kind of recovery. That's basically the essence of the argument in terms of how this is going to affect people in a pragmatic way as they recreate.
I think that is the gist of the argument, and that's what the court in Richie Gamester said, that when a person assumes a risk or understands and consents to a risk, then they have no cause for complaint absent reckless misconduct.
And your perspective is that, ultimately, and we've spent a lot of time on this, and your perspective is that a lot of people enjoy playing golf, a lot of senior citizens, a lot of folks enjoy playing golf because of the vast majority of sports that are out there. It's the type of sport, it's a non-contact sport, it's the kind of sport that seniors like to play, that older people like to play, and ultimately what you're saying is that in this situation, a person that's playing this sport, that's participating in this simply for the reason that it is, for the most part, safe, non-combative, non-contact, that ultimately that if you're on a golf course where their carts are used, that you are now going to assume, this heightened standard and this heightened risk that you're going to now have to invoke if you wish to go and do
I think the focus has to be on the knowledge and consent of the participant, and I think when we look at some of the risks that Brother Counsel accepts are part of the game of golf, such as being struck by a golf ball, that can cause extremely serious injuries.
But that's separate from the cart, and that's the whole point of this, is that that's inherent to the game. And I guess where we're going in a circle is that, it's really your genuine belief that the cart, which is an accessory to the sport, is ultimately, even if it puts, that if you go on the golf course, you get hit by a vehicle like a cart, that you've now assumed that risk when you're playing a game that you would otherwise see as a relatively safe game.
Well, it may be a relatively safe game, but I think you do undertake certain risks when you play a sporting event, and there are some serious risks in golf. You can be struck by a club, you can be struck by a ball, and those could cause severe injury as well, just like a cart.
Okay. Counsel, thank you very much.
Counsel.
Thank you, Your Honors.
Okay, we've completed our argument today. I'd like to thank Ms. Klingler, Mr. Bendur, and most of all, I'd like to thank all of you for being here, for your attentiveness, for your hospitality. I know we on the court very much appreciate everything that we've experienced here in Sault Ste. Marie in the last 24 hours. And finally, we look forward to seeing you at the reception in just several minutes. Thank you once again.
Good afternoon, everybody. Good afternoon. Can everybody hear me okay? Can you hear me? Is the microphone on? Is it on? All right. We are going to let the litigants just gather themselves for a moment and let the judges get in the back. We'll start with our question and answer session in just a second. But hopefully as you listen to that, you do have some questions that you thought of, and I'm going to invite you to come up and ask them. But we'll just maybe 30 seconds or so, and then we'll get started, okay? Usually over the microphone. All right, so good afternoon, everybody, or good morning. I guess we're still in the morning. My name is Tom Clement. I am General Counsel to the Michigan Supreme Court. And first, before we get started, I'd like to have a round of applause for our litigants today. as you can see, even in the relatively comfortable confines of the Michigan Supreme Court, which, while it's an intimidating courtroom, it's a much smaller courtroom, arguing in front of the Supreme Court is not the easiest thing to do, and it's a very intense 30 or 45 minutes. So having to come and do that in front of 600 or 700 or 800 individuals is doubly hard, and so we appreciate you being willing to involve yourself in this exercise. So thank you very much. Before we get started, I just want to thank and reiterate what Chief Justice Markman said on behalf of the Michigan Supreme Court. Thank you to Lake Superior State University, Judges Lambros and Blubaugh, who helped us today, Court Administrator Ojala, thank you very much. All the other judges who have taken their time to be here with us today. Our student mentors and educators especially, thank you very much. I understand that you've reviewed these materials with your students and you've had an opportunity to discuss them, so thank you very much. And then finally, the Chippewa County Bar Association for hosting dinner last night and the activities that the court and everybody involved with the court has been able to be involved in this last couple of days. Thank you very much. So for those of you that are involved here now, so we're going to have about 20 minutes or so for questions before we have to head over to the reception. The judges are taking a picture now and then conferencing over the case that you just heard, as Chief Justice Markman indicated. I want to direct you to 2 microphones that are here and ask you please to come forward and ask your questions. I'll call on whoever feels like coming forward, but please start making your way down now if you do have questions, and don't be shy. I do have some questions that I can ask, but it just doesn't go as well if I'm asking the questions. The litigants, the court, myself, and everybody involved with the court are interested in hearing what you have to say, what your comments are, what your questions are. So as I said, microphone here, and anybody that wants to come down, please do so. So as you're contemplating that, I just want to offer to the litigants an opportunity to come, introduce yourself, tell us where you're from, and then your general impressions of the argument that you just went through, please. And we didn't flip a coin or anything, so whoever wants to go first.
Thank you. I'm Sydney Klingler. I'm from Troy. I work in Troy, Michigan, for the firm of Seacrest Wardle, handling primarily appeals. It was a great argument, very interesting, and the justices always bring thoughts to the argument that come from 7 different directions. So it's very difficult to deal with those questions, but also very interesting and very, very rewarding. Thank you.
Good morning. I'm Mark Bendor. I work at the firm of Bendor and Thomas. I spent most of my time in downtown Detroit and have recently moved to an office in Grosse Pointe. My work is primarily appeals. I've been doing it for a long time. It is an interesting process. You try to prepare for the arguments and for the potential weak points that may be thrown in your face by the justices. But inevitably, in a spirited conversation like we had today, there come some that you aren't quite prepared for, so it's an interesting experience trying to think on your feet. Today, I think the justices were a little more active in their questioning than usual, but not a whole lot different than usual. And I think some attorneys look at judicial questioning that appears to be antagonistic to their position, and they get offended by it or things of the like. I think the better approach, and one I try to take, is to look at it as a chance to address what's on their minds, which is what we're trying to do as advocates, and to do your best to explain your position and deal with those thoughts before they are committed to a losing opinion. So what you saw was really, I think, the most interesting part of the oral argument process.
So let me just ask you in follow-up to that and to both of you, did the questioning take the track that you expected today, or did they take you down a different tangent than what you were anticipating in your preparations?
It was similar to what I anticipated. There were some wrinkles that I don't think I did. Sometimes you'll find the justices coming up with hypothetical situations that you hadn't thought through. But it's a little of each, I guess, is best I can put it.
I second Mr. Bendur. Most of the questions were questions that were anticipated, but some of you've read the briefs. Mr. Bendur came up with some great hypothetical situations, but the justices came up with even more different hypothetical situations. And as he said, some of those are situations you may not have thought about, and so you have to think. You try to think on your feet. And Justice McCormick brought up some questions that I hadn't looked at the case that way, because up until now the court has defined, well, we're getting into legal argument, but the courts have defined this doctrine, and so she said, should a jury do it? That's a new question, and so it's very interesting and always illuminating.
Thank you. It looks like we have a question over here. Please go right ahead. I think you might want to tap that microphone just to make sure it's on. Yep. All right, great.
Hello, I am Austin Plotkin. I go to Brimley Area High School, and I am in 10th grade. One question I have is the golf cart in this scenario a privately owned golf cart, or is it provided by the golf course? Because last time I went golfing, they made us sign a contract for using a golf cart, and we were only limited to 2, so I had to walk.
Well, if you had to walk with people who had a cart, I'm sure you could really relate to the problem we had today. Typically, this was, I think, owned by the course. That seems to be typical, their source of revenue. And usually the waivers are waiving liability of the cart owners or the golf course itself. I don't think they deal with injuries caused by other golfers.
Thank you.
Question. Yes, ma'am.
Hi, I'm Alyssa Burton. I go to Sioux High, and my question is, every time we get into a motorized vehicle, we always have to look out for pedestrians and people walking. Yeah, that's pedestrians. So my question is, why is it not the drivers? Like, why do people have to, how do I question this? Like, why is it expected for you to get injured by a golf cart because people who are driving the golf cart have to watch out for pedestrians?
That's a great question, and that goes to the heart of this case. That's what our Supreme Court discussed, and you recall we talked about the Richie Gamester case, and they said, and Mr. Bendur may want to rebut me here because I'll get into a bit of argument, but they said that when you participate in a game, and some games are rough and tumble and you may get hurt, and some are less so, like golf, but you still may get hurt. When you participate in a game, you accept that risk. And the question we're here to talk about today is that risk part of the activity? Is that risk that's posed by a golf cart part of the activity that you're undertaking? Does that explain anything?
Well, the person driving should know that there's people around, and they should be careful when driving the vehicle. So, yeah.
Let's let Mr. Bendur respond.
Who did you think won?
I think you hit on the nose one of our primary arguments, which is that everybody's required to be careful, and if they're not, they're responsible. And that was our position as to why this case was different than some of the others. But the defense, quite ingeniously, drew upon a case that involved ice skaters. in a rink where someone was skating backwards and ran into somebody else. And in that context, the court said that co-participants in a recreational activity are different, and they can be injured negligently without recourse. And so the tension of the case, I think, is between our argument that a golf cart and a car are really no different, and their argument, as I understand it, is based on the important point that they were co-participants and to some extent consented to the risk of being injured by one another. So I think you hit the key tension of the entire case.
Thank you for the question. Yes, sir.
Hello, I'm Jeremy from Whitefish Township School. So my question is more really a clarification of the whole case. You guys went a lot back and forth, and the defendants really went, the justices went back and forth. What is the whole aim for the case? Do you want to make sure that the golf course, if you do get into a golf course and a golf court accidentally hit you, you cannot sue or be liable, or they won't be liable for the actions or decisions they caused? They hurt the other person. You.
The rule that we'd like the Supreme Court to adopt is that you're only liable for activities in a golf game with a golf cart if you engage in reckless misconduct. So it's not that you can never be liable.
Okay, so it's for more improper use of the golf course instead of using it more for the game of golf.
Well, if improper use might be reckless misconduct, that would be something that probably a jury would have to decide whether what the person did was reckless or not.
Also, in the debriefing in the packet, it doesn't really state whether the driver was sober or drunk, mostly in my experiences with adult games.
We have no evidence that there was alcohol involved.
Okay. But would it change the whole outcome? That's my question, because you guys were talking about the motor vehicle code. If golf carts are really applied, couldn't you really, if you had some sort of alcohol brought into the situation or you're not of the right mind, would it change the whole case entirely?
Well, I understand that alcohol is not unknown on golf courses. I don't know that it might involve, you might rise to the level of reckless misconduct if someone is driving a cart while intoxicated. I don't know.
But, okay.
Actually, in a case like this, there are really two objectives. The most immediate objective is for her to win for her client and for me to win for my client. And the legal doctrines are almost a bystander. But the reason it's important to the Supreme Court is the precedent it sets for other contexts and other cases. And there is no alcohol involved. And I also actually did a check. There's a rumor that the golf course is 18 holes because a fifth of scotch contains 18 shots. And the old Scotsmen, once they ran out of scotch, ended the game. But it turns out that's only a rumor, and it's not so.
Thank you.
Yes, sir. And thank you for all of the questions, by the way. These are all appreciated.
I'm Nicholas Cox. I go to Sault Ste. My question was, you guys brought up, I think it was one of the justices brought up, different motorized vehicles being used. And I was wondering if both people, say they brought a four-wheeler and both people were co-participants, they both consented to using the four-wheeler as a method of transport between the different holes of the golf course. Why is it different if it's being used as a golf cart, even if it's not a golf cart? If it's being used as such, why would it be different?
If it were like an ORV or an ATV, it would be different, and this gets into our argument, because that vehicle is regulated by a bunch of statutes, a bunch of laws, and that makes it subject to the motor vehicle code, in a nutshell.
So if it was subject to the motor vehicle code, would the standard be different, or how would that impact?
Well, yes, the standard would be different. In fact, an ORV is subject to a statute that says you have to operate it with care, with regular care. So that makes it different.
So reckless misconduct wouldn't come into play?
No.
But my question is, if both people consented to using it, if both people looked at it and said, okay, yes, this is fine, we agree that there are some risks involved in this, and then something happened, if both people had agreed to the risks beforehand,
Well, I think the standard for under our law, the standard for an ORV is still negligence.
okay.
You want to answer that one? Take a shot at it.
I'm not sure that it would make a difference if the RV was being used to transport clubs or as part of the game, except that the previous Supreme Court case talked about risks inherent in the game, and the argument from the defense point is largely that golf carts have become so ubiquitous in the game of golf that they ought to be considered part of it. And I'm not sure that an ORV would be considered part of golf in the same way that a golf cart would be.
Thank you for the question. Yes, ma'am.
My name is Laura. I'm a student here at Lake State. So my question is, both of you heavily relied on the Richie Gamester case as a precedent case for this argument. Fundamentally, for both of your arguments, it was used heavily. So my question is kind of two parts. Is in a typical case, do you always try to establish precedent? Using another case, how heavily do you usually rely on that? And then when this case is decided, which precedent would you want it to set regarding golf carts on golf courses, I guess, is the question.
Yes, that is very typical to rely on controlling, on previous precedent from the court, and we always do that in legal arguments. And the precedent that we want to set, as Mr. Ben-Dur said, first of all, we want to win for our side, but then we want to, the Supreme Court, as he also said, wants to explore the parameters of the previous case. There's always things that are left undecided and that aren't, or fact situations that come up that aren't resolved by a previous case. It's inevitable. So that's what the court is trying to do in this case.
You ought to realize that the Supreme Court only accepts about 2% of the cases in which the attorneys ask for the court to take the case. So as a result, they're not taking cases that are completely controlled by prior precedent unless they are thinking of overruling them or expanding upon them or limiting them or something of that nature. And because they're Supreme Court, they're not bound by the prior decisions in the same way the Court of Appeals is, although they generally want to be consistent. This context, there was even greater reliance than usual because Richie Gamester is a relatively recent decision of the Supreme Court. And secondly, there are not very many other cases, and no other cases that I'm aware of from the Supreme Court itself, that are close to this. So bottom line is there's usually reliance on precedent, but it was more so in this case.
Hello, my name is Shelby. I go to Sault Ste. My question is about, you both said before the questions that there were times in the case where with 7 different opinions in different directions that they could have taken the case. How do you prepare for that? Because you guys were very quick on your feet to be there and support your argument despite it going somewhere you didn't think it would go. So how do you guys, even before you step in the courtroom, how do you prepare for what they might ask, what way the case might go, and how you can use the evidence you have to support your case further?
First of all, the Supreme Court orders can sometimes be very explicit in saying, we want you to address this issue. You can usually figure it out anyhow because there's only one or two legal issues that you've really joined forces on. For preparation, my general practice is to try to identify the three strongest arguments on my side and the three strongest arguments on the other side, and spend a special attention trying to prepare for the ones that are on the other side, figuring that the justices and the other attorney are going to call upon me to deal with that. So it's a pretty narrow focus to begin with, and hopefully you prepare to deal with those 3 weak points, but inevitably they come up with a different spin that you're not ready for.
Did that happen to you today?
I wasn't prepared about the stock card.
Okay.
We spend a lot of time preparing. I spent for 15 minutes, it turned out to be more than 15, but probably 15 hours preparing. And we just try to think of all the questions that the justices could ask, and I especially focus on what I see as the weak areas of my argument because I know that's where they're going to go. We know what the case is about. We've briefed it, as you know. You've read the briefs. So we know the issues, but they do still manage to come up with questions that may not be anticipated.
Thank you.
Did that happen to you today? Questions that you didn't anticipate? Was there any one in particular?
Some of Justice Friedman's hypotheticals were things I really hadn't thought about.
Thank you, Sal. And we probably have time for one or two more. I think the justices will be waiting for us with reception. You made a point about 15 hours of preparation for the argument, and I just want to emphasize the work that both of these individuals have put in for this. Preparing for a Supreme Court case is something like no other case that you can imagine. So there's not just the preparations for the oral arguments that you heard today. This has been briefed a couple of times, and it takes hours and hours and hours of research and writing to prepare those briefs. So I don't think it would be unrealistic to say that each of these individuals has put 100+ hours into just this case, and this certainly isn't the only case that they have. So be mindful of that as you're thinking about what was put into today's work. Yes, ma'am.
My name is Jenna Griffin, and I'm a student here at Lake State. And I was just wondering, you both mentioned that you focus more on appeal cases. So in terms of this, how is it different than your other appeal cases?
This case is a little bit different because, for one thing, we've come to the Michigan Supreme Court. That doesn't happen in the majority, and we've really defined it down to to an issue of law. So that's different. It's not always like that. I apologize. I misspoke Justice Bernstein's name a minute ago. This case is different in those respects.
One of the most interesting and rewarding parts of the work we do is that cases are unique. They involve ever-changing variety of legal issues in a variety of factual contexts, and that's part of what keeps it so fresh.
Another one or two, or you? All right. Yes, ma'am.
Hello, my name is Lydia Gilbert. I'm a senior at Sault Ste. Last Friday, we were told a little bit about the case. Unfortunately, there's a communication error, so we didn't get the same packet as the other schools did. But one question that I had last Friday, what was brought up is the golf cart was on the green where it wasn't supposed to be, and I was wondering why that wasn't brought up during the argument today. And I was also wondering what kind of effect that would have on, like, the legal ramifications of the defendant.
I don't think there was ever any question about the cart being where it wasn't supposed to be. I mean, it was part of the game that you drive the cart up to the area of the green, and then after You hit your shot onto the green, which is what the driver had done. You pull the cart around so that it's easily accessible as you walk off from that green to the next tee. So location of the cart wasn't really an issue. It's just not watching where you were going.
I think that leads into a good question now. Can you talk about the facts of this case? I didn't hear any wild differences between your two perspectives on the facts of the case.
No, there really aren't. According to my client, he had driven most of the day on the cart. He got off the cart, took a wedge and putter. He was near the green. He was going to hit a shot onto the green. It turns out he hit it over, so he was walking with his putter and wedge over the green to hit his next shot. The defendant, who had apparently hit a very good shot, was on the green, was taking the cart around. My client said that as he was walking, he unexpectedly got struck from behind. The defendant said that he was just driving and the plaintiff kind of jumped out in front of him. But other than that, I think the facts were not seriously in dispute.
Thank you for coming to the Sioux, by the way. I've enjoyed my time here. I've learned quite a lot.
Thank you. Another one? I think we have time for one more.
My name is Jude Cole. I'm from Gaylord, Michigan. I had a little personal question to ask you. How long have you guys been practicing law, as well as how many times have you stepped before the Supreme Court to give a case?
I've been practicing law since 1987, so that's quite a long time. I've been before the Supreme Court several times, but not in recent years. So this was a new experience in a way.
I've been practicing close to 45 years. I've probably had 50 arguments in the Michigan Supreme Court, and fortunately one in the U.S. Supreme Court, so I'm not entirely a novice at the process.
So clearly you were treated to two very well-versed practitioners this afternoon. What I'm going to do is I'm going to break here so that those of you who don't have questions to ask can adjourn to the reception that we're going to have. I don't know if the justices are ready for us or not, but I know that the room is ready. Are we good?
What we're going to do is anybody who is ready to go over to the reception, I'm going to ask that you can go now. We'll start with this section down here. Anybody who is not going to the reception, any of the schools who are unable to go because of time restraints, please stay in your seat. We will dismiss the buses last. So at this time, anybody who is ready to go over for the reception with the justices, please leave now. We'll start with this section down here first, and the first row is right here that include the justice system.
And just real quickly, for those of you who still have questions, if you want to come up, we're happy to talk with you about those individually. You over here, Tim?